Namaskar and welcome to Diplomatic Dispatch. I am Vikas Swarup, your host on this show, which brings you in-depth analysis of a new subject of international importance every week. In this week's episode, we will take up an aspect of international relations that is foundational to the world order and global politics, and yet one which many of us are completely unaware of. I am talking about international law. International law impacts all human activities on the planet, including everyday tasks that affect our daily lives. Every time we travel abroad, send an international letter, update our social media profiles, or take a patented medicine, we come into contact with some form of international law. Whether it is tackling pandemics, enforcing border control, the fight against terrorism, internet regulation, the determination of flight and navigation routes, diplomatic and consular relations between countries, data privacy, the use of postal and telecommunication services, industrial standards, cross-border environmental hazards, or adopting a foreign child, it is international law which sets the rules and regulations without which our dynamic global system would come to a halt. That is why international law is defined as the set of rules that are followed by nations when dealing with each other. The origins of international law can be traced back to antiquity. Among the earliest examples were the peace treaties between the Mesopotamian city-states, interstate pacts between the pharaohs of Egypt and the Hittites, customary law in ancient India and China, notions of governance and international relations developed by the Greek city-states, and the Roman concept of jus gentium, meaning law of nations, which regulated contacts between Roman citizens and non-Roman people. But as a definite branch of jurisprudence, the system now known as international law is relatively modern. It dates only from the 16th and 17th centuries, coinciding with the rise of nation-states after the Middle Ages, the introduction of the printing press, development of science, humanism and notions of individual rights, and increased navigation and exploration by Europeans, necessitating the need for rules of maritime intercourse and treatment of diplomatic agents. The sources of international law are many: treaties, custom, general principles of law recognized by civilized nations, Charter of the United Nations, judicial decisions, and writing of jurists. Unlike the law of the land or national law, international law does not have a recognized legislature, judiciary, or executive. Over the years, the range of subjects and actors directly concerned with international law has widened considerably, moving beyond the classical questions of war, peace, and diplomacy to include human rights, economic and trade issues, and international organizations and non-state actors. International law is extremely important to India, which is a party to more than 160 treaties and conventions dealing with various fields of law. Article 51 of the Constitution specifically enjoins the state to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations, and encourage settlement of international disputes by arbitration. That is why since 1957, the Legal and Treaties Division has been functioning in the Ministry of External Affairs. It advises the MEA and other ministries and departments on issues pertaining to international law and treaty, including treaty negotiations, practice, and interpretations. To discuss the various facets of international law and India's approach to it, I am now joined by two distinguished experts. In the studio is Professor Bimal Patel, a noted educationalist, jurist, and administrator. During his professional career of over 3 decades, he has served in various roles, such as the director at the Gujarat National Law University and member of the 21st Law Commission of India. He is presently Vice Chancellor, Rashtriya Raksha University, Gandhinagar, and member of the National Security Advisory Board of India. In November 2021, he was elected to the International Law Commission for a 5-year term by winning the highest number of votes from the Asia-Pacific group. And joining us from Bangkok is Dr. Kamalinne Pinitpuvadol, the Secretary General of the Asian African Legal Consultative Organization headquartered in New Delhi. He has a doctorate in international law from the University of Strasbourg. He has been the Executive Director of Child Rights AsiaNet, a regional organization which aims to promote and protect rights of children in Asia and the Pacific. He has also been Secretary General of the International Law Association of Thailand and an Associate Judge at the Central Intellectual Property and International Trade Court. A warm welcome to both my panelists. Let me begin with you, Professor Patel. Why is international law so important, and what is India's contribution to international law?
Will and consent are the two important pillars on which the international law system is based. And when we talk of India, India has been party to a number of multilateral treaties. India has been faithfully executing all its international obligations. And very importantly, India has been also adhering to the awards and judgments rendered by either by the International Court of Justice, by the ITLOS or WTO. In other words, India with diverse background, the new independent state in 1947, colonial yoke, despite the fact that international rules were not in favor of India and are not in favor of even today in India, India shows an extraordinary example of adhering to the norms of international law, unlike some other countries which believe in expansionism, which thwart the friendly relations, which India would always oppose. And as a country with 1.2 billion population and aspirations to become a major power in the world, has the all credibility to make sure that the international law serves the interest of the entire humanity and is based on the will and consent of states. And therefore, I believe that international law has never acquired so much importance as of today.
Secretary General Pinitpuvadol, how does your organization, ALCO, contribute to international law? And what are the challenges faced by Asian and African countries in contemporary international lawmaking?
If you go back to the history, how ALCO contribute to the international is mainly ALCO contribute in terms of progressive developments and codification of international law in some critical areas of international law. For example, the law of the sea, cybersecurity, investment law, etc. The rule of international law were framed by the European colonial powers. But after the Second World War, 10 years later, there's a big event in the first Asian-African conference we call the Bandung Conference, held in 1955 in Bandung, the capital of West Java in Indonesia. And many countries, we can say that newly independent states joined these events from Asia and Africa. And 1 year later, from the Bandung Conference, it set up ALCO, Asia African Legal Consultative Committee at the time, but the name changed to ALCO in the year 2000. And ALCO played a critical role since 60 years in terms of progressive developments of international law, and also be as the consultative organs for member states. In 1966, ALCO adopted a set of principles known as the Bangkok Principle on the Status and Treatment of Refugees. This is very important because many states in Africa and Asia did not join as a state member to the UN Convention on the Status of Refugees. And this Bangkok Declaration is go beyond more wider than the UN Convention on the Status of Refugees. I can say that during 60 years of existing, ALCO play a critical role and can be a platform or think tank for the Asian African countries.
And Professor Patel, you have just been elected to this body which was established by the UN General Assembly in 1947. So where does the United Nations fit into the international law system?
International Law Commission is one of the subsidiary organs of the United Nations General Assembly. And United Nations is the finest instrument to promote international law. Basically, international law is, as I said, the norms which are agreed upon by the member states. And United Nations simply facilitates through the means of codifying the state practice as well as progressive development of international law. Currently, the International Law Commission has some of the most important issues. And if I may say, there are sensitive issues such as crimes against humanity, issue of universal jurisdiction, immunity of state officials. These are politically highly sensitive issues in which one finds there is a clear schism between the advanced countries or European countries and some of the developing countries. At the same time, there are certain forward-looking constructive topics such as sea level rise, Now, what are the law of the sea issues? How to deal with maritime security? How to deal with the maritime delimitation issues which would occur because of the changes of the baseline? Similarly, environment and armed conflict, how these reconcile together? Displacement of persons. So these are also the issues which are typically classical issues of international law, which promotes what we, the developing countries, would call it. That is what they are looking forward. And the third set of issues is very classical. For example, when a state disintegrates or a new state comes into play, for example, Afghanistan. So what will be the responsibility of new Afghan government? Because the new government has succeeded the previous government. So state succession and the state responsibility issue will be there. Similarly, you will find the pandemic, which is the most hot topic. So how the International Law Commission can contribute, though it is a generalist body, to such a technical aspect by bringing into the issues of state practice, whether it can bring some contribution to the issue of pandemic. Because pandemic, the current pandemic, has to be not looked upon by the organizations such as PAHO or WHO. But I do believe that International Law Commission, because of its 75 years of history, and has been codifying and bringing the progressive development of international law, can and may play a very important role when the member states will be dealing with the post-COVID impact.
The International Court of Justice, based in The Hague, is the principal judicial organ of the United Nations, established in June 1945 by the Charter of the United Nations. How important is the ICJ to international law?
Yes, the ICJ is the judicial organ established under the UN Charter and for the settlement disputes between states. Is the part of the Charter and constituting as the court judge not judge individual but state. For example, if we look at the statute of the ICJ, under the Article 38, the ICJ apply the international customary law, the convention or treaties, doctrine, and also the convention and the judgment. And the judgment of the ICJ constitute the source of international law that the scholar and many agencies need to learn about the developments of the decision or judgment of the ICJ.
Professor Patel, there are several countries like the United States, Russia, China, France, Turkey, and Israel which do not recognize the compulsory jurisdiction of the ICJ. Where does India stand vis-a-vis dispute resolution at ICJ?
India, with all sincerity, has been the most proponent of the adjudication by the International Court of Justice. So far, India has been party to 6 cases. In each of the dispute which has been settled by the ICJ, India has adhered to those judgments delivered by the ICJ. Besides, India has also actively participated, there can be more participation, in the advisory opinions, which also brings clarity to the developing norms of international law. With regard to the compulsory jurisdiction, I can only tell that United States, after the famous Nicaragua case, opted out of the compulsory jurisdiction. France, after the famous nuclear test case. However, whether the famous 1971 case in which the ICO jurisdiction was recognized, which one can consider that India would not have preferred, would not have liked, but India never opted out. India has been amending its compulsory jurisdiction optional clause. But as far as the adhering to the judgments by the ICJ is concerned, India has been falling very clearly. That shows, unlike other countries, and that brings me to the earlier remarks, that India, with all the diversity, all the problems, has been having the only country major power in the world which can vouch and which can say the best credentials as far as the promotion and adherence of rule of international law is concerned.
So a recent case where India went to the ICJ itself was that of Kulbhushan Jadhav, who had been sentenced to death by Pakistan. Why did India take the case to the ICJ?
The similar kind of cases have been brought before the International Court of Justice. Avena case, Mexico, United States, as well as the 2 Lagrand case in Germany brought against the, and there was one more case in 1987. So India did believe in all sincerity that by bringing the case before the International Court of Justice, Pakistan would refrain from passing the sentence or conviction to Mr. Jadhav, and it will abide by the ruling made by the International Court of Justice. And as the ruling came in favor of India, India's stand with regard to the Vienna Convention on Consular Relations was upheld. ICJ also restrained Pakistan from furthering any process with regard to Jadhav case in the court.
Secretary General, the South China Sea and the Arctic Sea are hotly disputed areas where maritime law comes into play to regulate who gets to access these bodies of water. So what is the law of the sea and how is it implemented?
The law of the sea is a branch of international law that concerns law and order, involves oceans and seas, establishing rules governing all use of the oceans and their resources. And also the disputes about the boundaries in the sea is a kind of state disputes need to be resolved by the UN court. The UNCLOS under the UN Convention on the Law of the Sea. We have the Tribunal on the Law of the Sea who make the rule or judge the dispute settlements between states. So I can say that the law of the sea is very important, and in the past I'll go take some initiative to provide some platform for discussion amongst the member states for developments of international law of the sea.
What happens when countries refuse to accept an arbitration award given by the arbitral tribunal instituted under UNCLOS, as China did in the case brought by the Philippines on Chinese maritime claims and environmentally destructive construction of artificial islands in the South China Sea?
South China Sea dispute was the major award since the entry into force of the UNCLOS. This particular award has clarified the legal position of UNCLOS as far as 11 countries were concerned. In fact, 25 not verbals from 11 countries tell us that how this particular award is clarified. Let me give you a couple of examples. As you rightly mentioned, the land reclamation and artificial construction cannot change the maritime features, neither can undermine the legal regime which is well established by the UNCLOS. Number two, archipelagic state only can have the state baseline, which if any country would like to go for, this is also unacceptable. Third, as far as the maritime delimitation is concerned, this particular award also clarified what is the status of historical waters or historical claim. This particular award also made it very clear that as far as the Spratly Islands were concerned, the Spratly Island can only generate maritime features which can have only the 12 nautical mile territorial sea. I believe that South China Sea Award by the Permanent Court for Arbitration has clarified the position of UNCLOS, and it will help the future such kind of claims as well.
And what is the situation with respect to international economic law? On the one hand, preferential trade agreements have been proliferating, while on the other hand, negotiations in the World Trade Organization have faced numerous setbacks and delays. More and more countries are also increasingly questioning the absolute nature of many investment obligations as well as the legitimacy of the international treaty arbitration system. How can international economic law handle this challenge?
But after 2007, individual have not so many negotiations, and many states turn to bilateral or regionalism. For example, they concluded agreements as FTA or bilateral investment treaties. And also between the regions, we call the mega trade agreements or mega regional trade agreements. It means that it's a block of regional. For example, we can refer to the CPTPP, the RCEP, Regional Comprehensive Economic Partnership. Is composed of 10 member states of ASEAN, and also Australia, New Zealand, Korea, Japan, China, and before we have also India. But India, since I think the end of 2020, India just withdraw from the RCEP because of some fear of the issue of the imports, exports will be harm for the local importer. And I think that now the issue of trade agreements is very important, and many countries engage in the kind of negotiation. And also, apart from that, now we have the issue of settlement or disputes related to the trade or investment treaties. For example, we have the issue of ISDS. We call the investor state dispute settlements. It's very important because it allows investor or individual to sue the state if state violate the treaty or convention. For example, there are lots of cases, ISDS, more than 1,000 recorded by the UNCTAD, United Nations Commission Conference on Trade and Developments, more than 1,000 cases. And this is very important because now if we talk about the issue of the reform of the system of ISDS, perhaps we need to be the permanent court for investment. We need to develop the issue of the code of conduct for adjudicator or arbitrator. And there's a lot of many issues that will be happen in the next futures.
Professor Patel, international criminal law has seen a rapid development after the end of the Cold War. First, with the establishment of the International Criminal Tribunals for the former Yugoslavia and Rwanda, and then with the establishment of the International Criminal Court in 2002. But many countries, including the United States, Russia, China, and India, did not join the International Criminal Court. What was the reason for India to not subscribe to the Rome Statute of the ICC?
India has been proponent of nuclear weapons, anti-nuclear weapons, complete disarmament, as well as terrorism. The fact that the disarmament of nuclear weapons and terrorism have not been involved, which country would like to accept? Because it is the interest of India, a country like India, that those are by all means jus cogens, and those are not reflected in the ICC statute. Besides that, let's be aware that the ICC birth was in light of what has happened in the Balkan as well as in Africa. In other words, the African democracies themselves were not yet ripe for such kind of statutes. No surprise, therefore, the number of African countries are withdrawing. African countries are equivocally talking about the non-jurisdiction of the ICC. Besides that, there are insufficient checks and balances on the ICC judges as well as ICC prosecutors. Similarly, when we are talking of the procedural issues, for example, collection of evidence. So you are seated in The Hague and the collection of evidence takes place in Africa itself. Now this also again the question. Similarly, the supremacy of the Security Council over the ICC. Which country would accept? And country like India, it is very clear that when the Security Council can overreach the ICC statute and the permanent members basically, India cannot accept such kind of situations prevailing. And therefore, unfortunately, despite the fact that ICC is existing for last 2 decades, number of countries withdrawing from the ICC to that extent that some of the members of the ICC are facing persona non grata kind of situations in some of the jurisdictions, so clearly that the international community has to revisit the ICC statute in order to be credible to deal with the international criminal law. Having said that, I do believe that there is a need for universalization of international criminal law, which takes into consideration the regional approaches to international criminal law, which is currently missing. Not only the ICC, but also some of the issues which I just earlier mentioned to you, be the issue of crimes against humanity or immunity of state officials. In so long as the regional approaches, be it Africa or Asia or later MECA, will not be reflected, the international law will be always deficient of the universalist appeal. So if ICC would like to claim itself a truly universal organization or universal adjudicating body as far as the criminal law is concerned, I think it has to do some of the fundamental revisiting of the statute itself. And perhaps then India may consider looking into the prospects of adhering to the International Criminal Court. Let's be very clear. India is a proponent of any treaty, any international norm which is of universalist nature.
Secretary General, We recently saw space tourism become a reality with private rockets launched by Jeff Bezos of Amazon and Richard Branson of Virgin Atlantic. Will international law step in to provide regulations and laws for this unexplored and uncharted territory? And which are the other new areas where we could see the application of international law in the future?
Yes, the issue of the space tourism is quite new, and I think there's a lot of legal implication and many issue concerned. For example, issue of authorization, issue of supervision, registrations, certification of the craft and crew use, and liability also resulting from these activities. Is a lot of things to be considered. And now, if we talk about the issue of space law, we have in terms of international space law. Now we have many convention, at least 5 UN convention, treaties on outer space. May I mention there's a treaty on principle governing the activities of state in the exploration and use of outer space, an agreement on the rescue of astronauts, the return of astronauts and returns of objects launched into the outer space. And the Convention on International Liability of Damages caused by space objects is very important because liability, we can hear sometimes the objects from the astronauts go down and make some damage to people or civil servants, etc. And also the Convention on Registration of Objects launched in the outer space. And the last one, agreement governing the activities of state on the moon. We're talking about how we explore the moon and other celestial bodies. There's big components of the treaties regarding the issue of space. And I think the space tourism, we're looking for the future, how we can cooperate, and in terms of providing some news guidelines or some news issues to be taken into considerations. And apart from that, the issue of news, issue of international law today is when we're thinking of the issue of the pandemic COVID-19. I think that now the issue of the developments of international law regarding the COVID-19 is an hidden agenda. We're talking about the issue of the health, international law in health, and issue of also issue of the sea, as mentioned, Professor Bimal Patel, issue of sea level rise is very important also. Issue of the climate change, issue of the cybersecurity, and also issue of trade and investment law is very important today for international law.
That is all the time we have, gentlemen. Thank you very much for your very valuable insights. We have seen that there are some functions that only international law can perform. It alone can level the playing field for interstate interaction and commerce. It can also help solve many of the complex issues facing humanity. Put simply, global problems require global solutions, and we need international law to provide the rules for those solutions. Join me again next week for a new edition of Diplomatic Dispatch. Till then, good evening and goodbye.